I would like to now turn the conference over to your host for today, Ms. Michelle Cooper, Senior Vice President and Corporate Responsibility Officer. Please.
Questions that are more focused on your entity or specific questions, we can deal with those via email, or we also are going to provide our contact information, or also through discussions with your local corporate responsibility officer. But we're hopeful that this education will prove valuable for you in your fiduciary roles. I'd like to start with a reflection, a prayer, as we begin our meeting. So as we gather, Creator and Source of all being, we give you thanks for the beauty of this day, for the gift of this world, and for the gift of each other. We especially give you thanks for the gift of our vocation to Catholic healthcare. We thank you for the ways in which you become present to us in our service of the sick and the suffering, the poor and the outcast. As we gather here on this webinar, we ask you to be with us as we continue to reflect on this unique vocation and seek to live it more fully in the world. Open our eyes that we may see what you wish us to see. Open our ears that in our dialogue we may hear what you want us to hear. And open our hearts that we may feel as you feel toward those in greatest need of our services. Bless all that we do here in our gathering. May it be a holy work done in your name. We ask this in your name. Amen. Okay. So I'd like to also introduce Sharon Hager, who is one of the Vice Presidents for Legal Operations at CHI. She is going to be presenting some key regulatory laws and considerations. But before we do that, Dan, can we switch? Oh, actually, I can do that. Let me just. Dan, I might just have you do it. I'm having problems moving within the document.
No problem.
So if you don't mind moving to the next slide. The objectives for today are to provide an overview of some key regulations governing your fiduciary responsibilities, specifically as they relate to compliance oversight. CHI, as you may have been made aware, probably through working with your local corporate responsibility officer, has had several investigations over the past years. These investigations continue, and the government is very focused on healthcare operations. And so we wanted to take a few moments today to provide some overview of some key regulations that we expect our Audit and Compliance and Finance Audit and Compliance Committee, as well as our board members, to have a basic understanding of. And then we'd like to highlight for you some of the key considerations that you need to think about as you're overseeing compliance operations within your entity. We plan on offering these webcasts quarterly. The first one is going to be geared towards key regulations. We do know that our next one will be in August, and it will be focused on the HITECH Act, as well as privacy and security concerns, and I'm sure you and your roles at the local entities understand how important privacy and security is right now, and so we wanted to make sure and provide that webcast next. So Dan, if we can progress to the next slide. I did also want to mention to anybody that if you are not able to get into live meeting, we did have a few individuals that had difficulty with that. If you will please email Candy Gibbons, and it's CandyGibbons @catholichealth.net, and request a copy of the slides. She would be able to email those to you if you are now listening to the presentation. We will give instructions at the end of the presentation as well about how you can receive a copy of the PowerPoint that we are providing in conjunction with this webinar. I did want to just spend a couple minutes before we get into a specific discussion of some of the key regulations to talk about what are the areas of government focus, how have we really linked some of these focus areas to some of the governmental concerns. And I think everybody is aware of how much we are spending as a nation on health care. So the government is very concerned about the additional costs of health care. And in fact, just since January of 2009, the government has actually recovered $6.9 billion using the False Claims Act. And Sharon's going to talk more about that specifically. But what that points out is that the government, through Medicare, Medicaid, and some of the other state programs, has paid for services that really they should not have paid for. So they were billed incorrectly, or they were provided when they were not medically necessary. So there's several different reasons why the government's focused on this. But I think one of the key takeaways is that the government very much understands the complexity of health care rules and regulations, very much understands how difficult it is to send out a clean bill and document all of the services provided. And because of that, they understand that there are many mistakes being made by health care providers. And so we are at CHI very focused on those mistakes, very focused on what we can do to tighten controls to help ensure that our bills are going out correctly. And we're going to talk more about that. But we also are very focused on quality of care, and we do know that as we move more towards an accountable care organization and some of the models that CHI is moving towards, we are going to be reimbursed for providing better quality of care. And so it is going to be very critical that we understand that relationship of quality care to our reimbursement. We also need to ensure that we've got processes in place to make sure that we're providing care to all those that need the care. The government's very focused on that, and there's many laws that support that as well. We also need to be very concerned as we move to some of these new models, including accountable care organizations, that we are maintaining compliance with antitrust and some of the competitive provisions. And Sharon's going to focus on that when she talks about the antitrust regulations. But I think many of you are aware that we had a rather significant investigation in Towson, Maryland a few years back. We have since divested of that particular market, but that involved questions around clinical appropriateness and medical necessity of services. That continues to be a focus for the government. They want to ensure that the services we are providing are in the best interest of the patient and meet the patient clinical needs. So with just some of those concerns out there, I want to turn it over to Sharon and let her walk through the 4 regulatory arenas we're going to focus on today, and then we'll open up for questions periodically. So with that, Dan, he's already on there.
Well, thanks, Michelle. As Michelle indicated, there are primarily 4 regulations, statutes and regulations that we work with on an almost daily basis within the healthcare industry. And so we wanted to just give a very high-level overview, but certainly leave time for questions if there are any. The first one that Michelle, as she just mentioned, is the antitrust regulations, statutes and regulations. And these regulations were actually enacted between 1912 and 1916, and they were primarily geared toward breaking up the oil monopolies that existed at that time. And interestingly enough, the chicken farms and the monopolies that chicken farmers were engaged in. So there are basically 3 acts. There's the Sherman Act, the Clayton Act, and the Robinson-Patman Act. And although they all 3 address different areas of anti-competitive behavior, the basic premise of all is that it prohibits restraint of trade, creating monopolies, and entering into pricing that is anti-competitive or gives a particular market or a particular vendor or hospital, in our case, a competitive edge in the market. As Michelle said, we are moving into the areas of clinically integrated networks and accountable care organizations, and the antitrust rules and regulations, probably more so than ever before, are coming into play in the development of these networks. As we're looking at networks across cities and then across states, we do have to be cognizant of whether or not we are creating such a market share that we control the market to the exclusion of all others. So I think the takeaway for those of you on the phone as you're looking at your governance function is ensuring that those kinds of evaluations have been made, the analyses have been made. I will tell you that we're very diligent about that as we've put together 4 or 5 networks at this point in obtaining those analyses of market shares. But certainly it's a factor that's not always been present in healthcare unless you're doing some large merger or acquisition. So this is sort of a new routine area for us as we move into the CIN and ACO world.
Okay, Dan, if we can go to the next one. And we are on slide 5 for any of you that are not able to get on the webinar.
Okay, the anti-kickback statute is another statute that we work with here again, this one on a daily basis for those of us in the operations area. The statute was enacted in 1972, and interestingly, it was enacted to protect the patients and the program integrity of the then somewhat new Medicare program, which was enacted in 1965. And it basically prohibits the offer to exchange or to offer anything of exchange or of value in an effort to induce referrals, the payment of which comes from any federal health care payer. So Medicare, TRICARE, CHAMPUS, any of those government payers would fall under the anti-kickback statute. As noted, it is intent-based, so the government must prove an intent or a knowing and willful disregard to enter into an arrangement that you know could be at one level, basically just to induce the referrals. There are several safe harbors that you can fit into. The difference between the safe harbor and the exception that we'll see under START is that under the safe harbor regulations, you do not have to fit into a safe harbor. The government has developed these, and certainly we try to fit all of our arrangements into a safe harbor because the government, that would be a favorable fact that the government would look upon in the event that we were subject to an anti-kickback investigation. The three that we use the most are the employment, the professional personal services arrangements, and the lease arrangement. Now, there are others that, as we go deal to deal, we may look at separately, but these are the ones that we deal with on a daily basis. Generally, if we fit into the START exception, we do fit into the kickback safe harbor. So many of the criteria or the elements in the safe harbor are the same as those that are contained in the START exception. Interestingly, there's been a lot of case law surrounding this, and there was a lot in the late 90s and early 2000s centered around healthcare and healthcare providers. And the one thing that I think the takeaway from that for those of you on the phone is what we call the one purpose test, and this came out of a healthcare matter where the government presented the argument and the courts agreed that if one purpose of an arrangement is to induce referrals, then the entire arrangement itself could be deemed illegal. So even though there may be other business reasons to enter into an arrangement, if one reason is to induce the referrals, then the entire arrangement is deemed to be illegal.
Okay, next slide.
Next slide. As I said, this is an intent-based statute, which to some degree feeds right into the criminal and civil penalties when you're looking at the sanctions available to the government in an anti-kickback investigation and ultimate finding that there was a violation. The civil side is consists of fines and penalties. The penalties can be up to $50,000 for each act, plus 3 times the total amount of the remuneration that was paid under the agreement. And I want to just make a differentiation here. Under the anti-kickback, unlike what you will see under Stark and the False Claims Act, this is for each act. So it would go back to the arrangement. So if you only have one arrangement, then you're looking probably at a $50,000 penalty plus whatever damages would be assessed. So it's just each arrangement, basically, that is entered into that could give rise to the civil penalties. The statute also provides for up to 5 years in prison, regardless of whether any of the remuneration was lawful, and that goes back to the one-purpose test. It can, if civil penalties are applied, it can result in exclusion from participation in the federal health care programs. If there is criminal findings, it is an automatic exclusion from participation in the programs. Okay, the next set of laws and regulations we deal with, and this one truly on a daily basis, is the physician self-referral law, or what is more commonly known as the Stark law, courtesy of Senator Pete Stark. Basically, this law addresses the inherent conflicts of interest which the government perceives exist between physicians and hospitals. The government truly believes that that any arrangement that a hospital enters into with a physician is done solely for the purpose of inducing referrals and to ensure that services at the hospital are utilized, thereby leading to overutilization and an increase in costs. And I have heard many government officials express this both officially and unofficially. So the view is immediately that we are intending to do something wrong. This is a strict liability law. In other words, proof of intent is not required. All the government has to find is that you are either in compliance with the exception and with all elements of the exception, or you are out of compliance, and therefore the arrangement does lend itself to potential fines and penalties. And here again, this is different than the anti-kickback statute, where they do have to determine intent. What does the Stark Law prohibit? Basically, as a physician or a physician's immediate family member, and we will define that later in the presentation, but let me just say it's a very broad definition, and it goes from spouse to in-laws to step relatives to grandparents to grandchildren. So it is a very broad definition. So if a physician or any of those individuals have a financial relationship with an entity, and that means any kind of employment relationship, lease arrangements, any types of personal service arrangements such as medical director arrangements, those are considered, basically, those are considered to be strictly for the referral base, as I indicated earlier, and the physician cannot make referrals to the entity for any designated health services. And here again, designated health services, it's easier to think of it as inclusive and to try to define the exclusions, but basically it's any and all inpatient and outpatient services which are provided by a hospital. The hospital in those instances cannot file claims for payment unless they fit into an exception.
Dan.
What I will say is there are about 23 exceptions to the Stark Law, and basically the ones, I'm just going to point out the ones we generally use, which is the rental or lease, employment relationship, personal service arrangements, and in our smaller markets, physician recruitment exceptions. We're not generally able to recruit in the urban markets, but we do use the physician recruitment exception extensively in some of our smaller markets. We threw the fair market value exception in there because I call this the exception of last resort. If we can't make it fit anywhere else, many times we can make it fit into fair market value, but it is not our most favorite exception to have to use in order to justify an arrangement. What these arrangements all have in common for the most part is that they require the arrangement be in writing, that it be signed by all parties to the agreement, and that the remuneration or payments under the agreement are based on a fair market value analysis. And so those of you I know that sit on PTRCs or have participated in those kinds of discussions know that that's one of the things that we always bring forward is the written agreement and certainly the fair market value analysis.
So we might just mention that PTRC is Physician Transaction Review Committee in case there's anybody on the call that's new or has not heard that term previously.
Great, Michelle. Thank you. Next slide. The Stark Law penalties are strictly civil, so there are no criminal penalties associated with the Stark Law. But basically, any claim submitted for payment when you have an arrangement that is not in compliance with one of the exceptions is a prohibited arrangement. Now, I want to point out the difference here with claims versus acts. Claim means every bill that is submitted for payment, and that can be a substantial number. For instance, you go back 6 years to look at the payments made to a hospital may only total over a 6-year time frame $500,000, but you may have thousands of claims because some of those claims may have only been for $100 to $200. So here's where the difference between the kickback and the Stark penalties can be substantial, and that's that it's every bill that's dropped, every claim submitted pursuant to a prohibited arrangement is subject to the penalty. Any monies that were collected during that time frame have to be refunded to the government. And then there are additional potential monetary penalties of up to $15,000 per claim, and then 3 times the amount claimed if the government so chooses. Improper claims can result in exclusion for the Medicare program. Not always, but certainly it is the shadow that is lurking is the exclusion from the program. What that means, and I probably should have clarified this earlier, exclusion from the Medicare program means that you cannot participate in any federal programs, nor can you be paid for those. And those of you, particularly maybe on the finance committees and some of those, know that we're very dependent on Medicare patients and federal payers in some of their markets. And also understand now that the third-party payers, the Blue Cross and the Aetnas of the world, are starting to follow suit, so that if a hospital is excluded from payment, there is the potential that they will be excluded from all payments, which, as all of us know, would shut the doors of our hospitals. Next slide. Financial relationship basically constitutes any payment made by a hospital to a physician, or it can be in certain instances, particularly with leases, payments from the physician to the hospital. The ownership, investment, and interest, it just basically is an entity that furnishes designated health services. And this can be direct or indirect. And where this becomes important is when we're looking at perhaps physician-owned ambulatory surgical care centers, physician-owned clinics with which we have some type of a relationship. Next. As I said, designated health services, it's easier to just define them as everything in inpatient and outpatient hospital services. You will see that there is one exception listed here, lithotripsy. There are a few others that we're able to rely on, pathology and radiology, because it's been determined that those physicians do not make referrals to the hospital. So there are some very limited arrangements that we're able to enter into where the Stark Law is does not come into play. However, for the most part, the easiest way to look at this is that all services provided by the hospital are considered designated health services.
And for lithotripsy, Sharon, can you define what that is for those that would not know what that
service
is?
It is a service that's usually provided by physicians who work in the area of kidney and renal, and it is a method of ultrasound water to kind of break up kidney stones. And this has been accepted. It's been controversial because most of these are owned by physicians and then leased to the hospitals. And so that's been an area of controversy, but so far it's still there. But it's basically that these physicians who practice in the area of kidney and renal disease own these machines, and then the hospital leases those for that. And this kind of comes and goes. The kidney stone, if we start to see an uptick in claims for lithotripsy, then you see the government exhibit more interest in it. Right now, kidney stones don't seem to be the diagnosis of the month, so we're okay.
We might have lost. Dan, are you able to move forward? We might have lost the connection, but hopefully everybody else hasn't.
I've moved forward.
Okay.
We're on slide 14 now.
Okay.
Yeah. Immediate family member, as I said, this is taken from the IRS definition, and it's very, very broad. As you can see, it includes spouse, birth or adoptive parents, children, siblings, steps, in-laws, grandparents, grandchildren, spouses of grandparents or grandchildren. So it's very, very broad. We do ask that one area that we do check as we enter into arrangements with physicians are to disclose family members. We also do a conflict of interest check with individuals that we believe to have a relationship with a physician to ensure that we're covering those bases and identifying the potential conflict. Does not mean that we cannot enter into the relationship. We just have to ensure that it complies with one of the exceptions. Do you want to take some questions?
Yeah, we're going to try to refresh our screen. So, Dawn, would you mind instructing people how they can go about asking a question? And we'll just pause and see if there are any questions right now.
Ladies and gentlemen, if you have a question, please press star 1 on your phone. If your question has been answered or you would like to withdraw your question, press star 2. Questions will be answered in the order received. Please press star 1 to begin.
Okay, so Dawn, I'm taking that as we have no questions.
As a reminder, if you have a question, please press star 1. There are no more questions at this time.
Okay, we're moving on to slide 15 then. This is the False Claims Act, and this is really, this is the big dollar ticket item for the government. The False Claims Act was enacted in 1863. It's also known as Lincoln's Law, and it was primarily designed in the early 1860s to address issues with vendors supplying either or not supplying or supplying subpar equipment and products and services to the Union Army. It was then carried over and used during the Reconstructive period after 1865 in the South as they were rebuilding the South. So that was its primary purpose. It's been used throughout the years in many different areas and was expanded to include the health care programs in 1986. It basically establishes liability for any person or entity that knowingly causes a false or fraudulent claim to be presented to the government for payment. So anytime a payment goes in, there is the potential that it's a false or fraudulent claim. Knowingly is defined as actual knowledge or reckless disregard of knowledge that you should have perhaps known that the claim you were submitting perhaps was a false claim. I will tell you that the government usually relies on reckless disregard because it's very difficult sometimes to show that there was actual knowledge that someone on the team was knowingly submitting a claim. So the government really looks to reckless disregard. And many times that's looking at whether or not there was a pattern that was established or something that should have caught someone's eye and made them look at things. As Michelle referred to Towson earlier, one of the things that we looked at there as we were looking at the False Claims Act liability there was the fact that one of the physicians there, as Michelle mentioned, perhaps was performing medically unnecessary procedures. And the numbers were so high that the government felt this was something we should have known, perhaps didn't intentionally or have actual knowledge of, but should have known that given the pattern that we were seeing, that there was potential for some type of perhaps wrongdoing. Here again, this is a strict liability statute. Like the Stark Law, it does not require that the government prove any intent. Moving on to slide 16, some of the examples of False Claims Act liability. Medical necessity, that's a big area for the government focus at this point, and we are seeing more and more indications of that, not just within CHI, but elsewhere within the hospital industry. Having an arrangement which is outside of a Stark exception, so any claim that would be submitted when you were out of compliance with a Stark exception gives rise to potential false claims liability. Overcharging for services or products provided or delivering the products or services, not delivering or sub-delivering those products or services that were promised. And a big one is billing for services that were not provided at all. And unfortunately, we have seen that within the industry where hospitals have actually submitted claims for that.
Well, I was just going to mention, too, that for any of you that are watching the news, you may see quite a few claims coming, especially Florida, Texas, California, some of those markets where individuals are setting up sham companies and they're actually approaching senior citizens, getting their information, and billing on behalf of those patients when actually no services were provided. So the government is very much focused on this from a false claims perspective.
Absolutely. And I will tell you, one of the biggest cases where a hospital administrator was actually indicted and found guilty under the Kickback and False Claims Act was a situation where contracts were entered into with two physicians where services were not provided, and the administrative team knew the services were not being provided. So that case is probably the early to mid 2000s, but it certainly is a reminder that you cannot enter into relationships or into service agreements where we know the service is not being provided. Moving to slide 17, here is the carrot within this for anyone that is out there, and that's the whistleblower provisions that are provided under the False Claims Act. And basically, this provision is designed to encourage any individuals who think they have knowledge of fraud and abuse that's being committed by a physician or a hospital to actually provide information to the government or, in some instances, to actually file a lawsuit on behalf of the United States alleging this fraud and abuse. The government has an opportunity to intervene in these lawsuits, and the last statistics that I reviewed, probably about 50 to 60% of the time the government will intervene. The other times the whistleblower is able to proceed on their own without benefit of the government assistance, but certainly can proceed through the court system on their own. The advantage here is that any recovery that is made by the government, either by the government after they've intervened or by the whistleblower on behalf of the government, that whistleblower can be entitled up to 30% of the recovery, including attorney's fees and any expenses that they had incurred in bringing the case forward. The best example I can give of this one recently was within the last couple of years, and many of you may have read about this in the news. It was the Christ Hospital in Cincinnati, where a physician on staff filed a case. At the end of the day, Christ Hospital settled for $104 million, and the physician whistleblower received about $30 million of that. So there is huge incentive on the part of individuals to sometimes look for potential fraud and abuse because there is certainly a carrot out there to entice them to become whistleblowers. As Michelle said, this is the big area of monetary recovery, $6.9 billion, with $1.3 billion of that going to the various whistleblowers. Moving to 18, sanctions and penalties. This is both a civil and criminal statute and regulation. The civil penalties can be anywhere from $5,500 to $11,000 per claim again. So like the Stark penalties, it relates to the number of bills that were actually dropped pursuant to these arrangements, and then up to 3 times the amount of damages that were incurred. The criminal side can impose additional fines. Those are very loosely defined within the statute. The other thing is it can provide for imprisonment. Unlike the kickback statute, it is not defined within the False Claims Act, but rather looks to the federal sentencing guidelines to determine the length of potential imprisonment. That goes directly to the case that the government presents, and it relates back to intent, knowing and willful disregard, and those kinds of things that they would take into account in looking at the federal sentencing guidelines. The other area that is quickly becoming active, or that many states have enacted their own False Claims Acts related to their particular state Medicaid programs. Because so many states now are, their Medicaid programs are financially strapped, we are seeing an uptick in activity by the fraud and abuse units in these various states pursuing Medicaid false claims. Those are strictly related to the states, and we're seeing a lot of activity, not necessarily in many of our markets, but just in general looking across the U.S., you're starting to see many of these states really pursue false claims activity. I would say it's not been as active since the late 1990s, when you saw a great deal of activity under the Medicaid fraud and abuse, as you're starting to see now. So look for an uptick in that particular area, because I think we're going to see more of that on the horizon. Michelle, I'll turn it to you.
So let's pause and just, Dawn, if you wouldn't mind asking again if there are any questions before we talk about the fiduciary role.
Ladies and gentlemen, again, if you have a question, please press star 1.
Okay.
There are no questions at this time.
Thank you. All right, well, let's talk a little bit about your role in the compliance oversight given this increasing regulatory environment. One thing I will mention just on the False Claims Act, even with the Towson case, for those of you that are not aware, when we settled with the government, we did become aware that there were whistleblowers involved in that case. They were actually 3 physicians, and they split about $2.9 million between the 3 physicians, and that payment, the amount that we paid related to that particular investigation was around $22 million. So CHI does have firsthand knowledge of what it's like to go through one of these cases where there are whistleblowers involved. I did also want to just mention that we do know there are 1,200, currently there are 1,200 whistleblower cases that have been brought forward to the government. They're in the decision mode, so the government's deciding whether or not they're going to pursue those. But that just points out the fact that given the size of our organization, CHI as a whole, we may have potential additional whistleblower cases out there. So as we continue to evolve our compliance program, one of our focus areas, and I'm on slide 19 now, is to really build a very effective CRP reporting process. And as many of you are aware, you are receiving updates, especially in the Audit and Compliance and Finance Audit and Compliance Committee meetings. You are receiving our CRP scorecard and our CRP monitoring scorecard. Those scorecards are designed to provide you with information you need to understand what processes we put in place, what we're doing to monitor activities to help strengthen and mitigate our risk of individuals bringing forth matters to the government. Our hope is that we are creating a culture where employees feel comfortable coming forward to us, raising any concerns they have, knowing that CHI embraces through our mission and our values a philosophy of repaying anything that we have done in error. And everybody knows that the regulations are very complex. I mean, even just some of the payment regulations and the various processes that have been put in place across the continuum are so difficult that we are going to make mistakes. We recognize that. We actually understand that and encourage our employees to, pay attention, recognizing the fact that they can't do everything exactly right. It's very manual. It's still a very manual system. And, in fact, just this last week, we listened to a webcast that the government put on specifically around electronic health records, and now new concerns that are surfacing at the governmental level around electronic health records and how they believe electronic health records may be used to foster fraud and abuse, in that providers will, code at certain levels and provide services at certain levels, regardless of actual need, and bill for services that were not provided. So we're very much paying attention to the changing landscape, to the various regulations, and the impact automation is going to have on everything we do. Because when you do automate, it just takes one error for it to have systemic impact on many bills going out the door. So one of the things we do want you to know is that we are constantly looking at activity. We're looking at trends. We're routinely checking our coding and billing and ensuring that we are focused on risk so that we can provide some comfort to our fiduciary our fiduciary leaders or board and compliance committee members to understand that we are paying attention. On slide 19, we did put some of the specific things that we've put in place. Many of you are aware that we have adopted legal policy number 9. That policy has been in place for a little over 2 years now. It requires every physician arrangement to be in writing, and for those arrangements to go through a board committee, the Physician Transaction Review Committee that Sharon mentioned earlier. We've also put in place a very strict policy around gifts and payments from business sources. This is to help mitigate our risk when it comes to conflicts of interest, also involving our physician partners and our employed physicians. We are right now, I'll just mention, putting together a physician-owned vendor distributorship policy that's going to govern all of our physician relationships, whether they're employees or non-employees, but that will allow us to have specific review processes in place when we contract or pay or receive services or receive payment from a physician that actually has an ownership interest in one of the vendors that we purchase services or products from. The government is very much focused on those relationships when the physician is an owner in a vendor and we are buying those products or services, and they're concerned about, is that influencing referral patterns, is that increasing the cost of health care? So we're continually watching the changing regulatory landscape and responding to those. One other thing that I'm sure you have heard from your compliance officers or your corporate responsibility officers is we are very much moving to a modality where we look at our data, where we look to see if we have a physician that is an outlier, that is providing too many stent procedures, that is, beyond reason, and we're comparing that to, standards across the United States as well as standards within our organization. So we are very much focused on outlier reviews. That will help us identify potential problems that we have, hopefully, before the government points those problems out to us directly. We're also putting a very strict conflict of interest policy and hoping to expand that to all of our physicians. Currently, we only solicit conflicts of interest from employed physicians, but this fall we're hoping to enact and have that policy in place that will cover all physician relations. We've also put in a very strict due diligence review process, so as we're employing physicians, we are actually looking at medical necessity. We're looking to make sure that as we're bringing on physicians that we feel they're a good fit from a legal standpoint in doing, providing appropriate services, but also to help mitigate our risk of bringing on new physicians. We want to know that their bills are going out correctly. So we have a very stringent due diligence process that we've put in place. And then I mentioned ethics point and the fact that we do encourage employees to bring issues forward. And I know many of you have seen that on your scorecard, just how many calls we receive. We have a process for responding to all those calls, and any issues that are identified are resolved, and we track all of that. Many of our compliance issues have actually been brought forward through that reporting mechanism. We embrace that, and we encourage employees to tell us any situations where they do not feel matters are being addressed appropriately. Next slide, which I believe is, we've got a couple more slides, slide 20. Your role, what can you do as a compliance committee oversight member, board member, or as a board member? Approve key policies and procedures that come forward as you're reading, publications and you see issues arise in the healthcare arena. If you do not feel that your entity has a policy addressing those, or you've never heard anything about it, be sure to ask questions around that, bring those forward. We want you to feel comfortable that we're responding to the changing landscape. Understand your organization's corporate responsibility program. Make sure that you are receiving quarterly reports from your corporate responsibility officer, and that those reports are being taken up to the full committee or the full board in summary format. Participate in ongoing compliance education. We're hoping that these quarterly webcasts will help you understand all of the difficulties and complexities, maybe not all of them, but at least some of them, that'll help you in your role as fiduciary leaders. Continue to receive updates on open investigations. If you have not heard of an investigation going on at your entity, it's okay to ask that question and say, have we had any investigations in the last 12 months? Is there anything I need to be aware of as a compliance oversight member or a board member? Make sure that you're receiving a report on key compliance risks that have been identified and that management is responding to those risks and that you feel comfortable that they're adequately addressing those risks. And then through the scorecards and through the CRP updates that you're receiving, make sure that you feel comfortable that they're meeting all elements of an effective compliance program. And we have standardized our CRP update reports, so each of the Audit and Compliance and Finance Audit and Compliance Committee members should be receiving a summary, and it's actually designed to meet the 8 elements. So hopefully you're receiving those. If for any reason you're not, please circle back with your local corporate responsibility officer to make sure that you're receiving those. And then next slide, slide 21, we have just put some actual questions that you can ask as you're receiving reports from your corporate responsibility officer, things that you should be aware of, and just some examples. And I'll just go over a few of them. Have any physician arrangements not been in compliance with the physician contracting process? So, what processes are in place either through the internal audit reviews that are being done or through the compliance reviews that are being done? How are we sure that our physicians are meeting the contracting policy? Were any physicians compensated above fair market value? If so, was there a reason for it? Do we have a legal opinion supporting that payment? But really just understanding what is going on with regards to physician relationships. Have any systemic coding or billing issues been identified in the past year? If so, have any associated repayments been made to the government? So if you do see a CHAN internal audit report coming forward, or you see management bring forth an issue and you are not sure how they resolve that issue, it's appropriate to ask the questions and say, did we repay any associated overpayment? Do any of the entity physicians have any ownership interest in a contracted vendor? If you have not, if those have not come forward to you, it would be good for you to ask that question. So far, I can tell you, systemically, we've only identified a couple of physician-owned distributorship arrangements, but I will tell you there is a law that's going into effect in August called the Physician Payment Sunshine Act, and that is going to require vendors to actually report any payments to physicians. And so we as an organization are going to be able to search that database. We're actually going to be able to take our physician credentialed file, match it against that database, and determine if any of our vendors have made direct payments to our physicians. So that's going to help us from a conflict of interest standpoint, and also just to ensure we understand our relationships between our vendors and our physicians. And then lastly, what controls are in place to mitigate any of the risks identified above. So in your role, what you really want to do is understand what are the compliance risks that your organization is faced with, and what is management doing to respond to those risks.
And Michelle, if I could just add one thing, it's sort of in follow-up to your comments about CHAN. One of the things that we found, particularly in Towson, but we have encountered it elsewhere, are that the CHAN audit results generally are presented at least to the Audit and Compliance Committee, Finance Committee, to the whole board. It differs depending on which MBO. But if you're seeing a trend, or you're seeing that these audits have not been responded to, and they continue to miss the deadline that has been agreed upon by CHAN and by management, that particular issue would be resolved, and you're continuing to see dates push out with no resolution, ask the question about what is being done. It becomes more difficult when we're having to deal with some of these issues with the government, but some of these issues have languished for 12, 18, 24 months and not been resolved. So what I have found has been a great deal of help in sometimes getting to resolution is the board or committee members asking that question as to why are we so far out in reaching resolution. Sometimes there's very good reasons why, and other times it's just sort of fallen off, off of the radar screen because of everything going on. But I would add that.
Great advice. Okay, so I know that was a lot of information to present, but we're hoping it was helpful, and I do want to open up for questions. I'm hoping we will have some questions. If not, We have included on the last slide our contact information, so I would encourage anybody to feel free to contact either Sharon or I with any questions you might have. I also encourage you to continue to have dialogue with your local corporate responsibility officer. They're really there to serve you and have a dotted line reporting responsibility to the Compliance Oversight Committee. So we want you to understand, to have a good relationship with them, to feel comfortable bringing forth questions or concerns, and also for them to be an avenue for you to communicate where you would like specific education. If there are additional areas, we would even encourage you, when we move to questions and to open discussion in just a minute, if you have ideas for additional topics that we could present that would help you become even better fiduciary leaders within our organization, we welcome that. So with that, I'll turn it over to Dawn and ask her to open up the lines again for any feedback anybody has. We'd also like to hear from anybody if you think these webcasts will be helpful to you in your role.
Ladies and gentlemen, again, if you have a question, please press star 1. There are no questions in queue at this time.
Okay, well, we finished about 5 minutes early, and again, I just encourage you, if you have any follow-up questions or anything, please let us know. In the meantime, I would like to also add that if you would like a copy of this PowerPoint presentation, we will be providing these to your local corporate responsibility officers. So if you would please email them directly, they'll be happy to provide you with a copy of the presentation. So thank you for your participation. We will be sending out information about how you can access this webcast for any of your members that were not able to participate in the live meeting, or if you would like to listen to it again in the future. And it will be available for many years. So we're hoping as you bring on new committee members, new board members, we will have this library of informative webcasts that they can listen to help them in their roles. So thank you for your time.
Thank you.
Bye.
Ladies and gentlemen, this concludes today's conference. Thank you for your participation. You may now disconnect. Have a great day.